All rise. We will be. Please be seated.
We're in open session, Your Honors.
Thank you very much. I think we've exhausted our discussions on the matter. We will make a ruling. The prosecution has clarified that the purpose of tendering or seeking to tender the document was not for the value of it on the matter of gender-based violence, but rather for background information, including on questions of tensions between the political parties prior to the election. The defense have argued that there is prejudicial effect that overrides that limited background information. The chamber is persuaded by the concerns raised by the defense. As a result, this is one document that the chamber will not be admitting. Of course, it is one thing to say that a witness who has come and testified to being a custodian of a document would have established the authenticity of that document for purposes of, yes, this was a document that was once created and kept, but then that is not the end of the assessment. The chamber would also take into account the prejudicial effect of such document, assuming it is found to be relevant. On that basis, the chamber will be rejecting this particular document.
As the court pleases. Thank you, Your Honor. We can turn to the second document that we would like to show the witness. And this document as well should not be displayed to the public, given the confidentiality nature of the information contained therein. And the ERN number is 00020015. And it appears at tab 4 of the OTP bundle.
Did you again indicate to the defense the parts of this document you intend to rely on?
With it, Your Honor. We emailed the relevant sections to the defense before coming to court this afternoon.
Counsel?
Yes, I've received it, and I'm just going through it at the moment, actually, so slightly divided in my attention. I apologise.
Oh, right.
But yes, we've had a flagging up of the relevant portions that the prosecution are interested in. Thank you. Right. Thank my friend.
And the prosecution seeks. What do you intend to do now?
I would like the witness to examine the document and.
Mr. King-Katwa, you have received the relevant parts.
Yes, we've just received it.
Thank you.
Perhaps, Your Honor, with your leave, in order to make this exercise more efficient, if you approve, we could show the witness all the documents we intend to put to him, one after the other, excuse the witness after the identification of the documents, and leave the rest of the afternoon for the legal arguments of the parties, if you approve.
We can assist to this extent that, for our part, we agree that the documents the prosecution are going to produce this afternoon are documents that this witness has recognised as being produced to SIPEV, which I think would satisfy the objectives that my friends just suggested she dealt with by showing the witness each of the documents. In other words, we agree that as a fact.
We take the same position, Your Honours.
And we're now talking because Mr. Hooper, that information, of course, is in the witness's statement.
No, it's not, because most of the documents he's touched on in his statement are not, in fact, the documents that the prosecution are going to adduce. The documents the prosecution are going to adduce were shown to the witness last week. We've received, of course, a note or summary of those discussions the prosecution had with him in his pre-trial meetings. And so we've had the advantage of seeing that. And I see that in those documents, he's shown these documents, and he identifies them as documents that were received by SIPEV.
More than what's in his statement.
Yes, because we've gone up to paragraph 66 of his statement. After paragraph 66, paragraph 67 to the end deal with other statements, other documents, only two of which, one of which we just touched on just this morning, only two of which form part of the intended group of documents that the prosecution are using the witness to introduce. So last week he was seen, and a further, whatever it was, 10 documents were shown to him. Amongst those 10 documents, all of which he recognised as SIPEV documents, and amongst those documents are the documents the prosecution are seeking to introduce now. So our admission goes to his recognition as someone attached to the SIPEV commission, that these were documents that passed through the SIPEV portal, as it were.
And you do not dispute that. You admit you do admit that.
We do admit that, yes.
Right. Yeah. And Mr. Kinkatwa, the same for you?
Yes, Mr. President.
So, Ms. Sago, the point then being, the defense are happy to admit that those were SIPEV documents. So then the issue now is a matter of their admissibility, in fact, for other reasons.
For at least one document, we would like to ask follow-up questions to the witness and have those questions in the record of the proceedings. Therefore, it would be important for the witness to examine the document and walk the chamber through that document to the extent of his knowledge. Thank you.
So then you are happy to accept the defense's offer for the other documents, except for one.
Yes, that is correct, Your Honor.
Can we then go straight to that one document?
Yes, Your Honor. I'd like the following document to be displayed. And the document has a component that is probably public and another section that is not public. But the document is one document. Therefore, I'm in your hands as to the display to the public, the curtains, and the arrangements for the analysis of this document. The year-end number of this document is KenOTP 00058554.
Let us display the part that can be displayed to the public, but when we get to the part that you said should not be displayed to the public, then we act accordingly.
Certainly, this first page can be displayed to the public. For your honor's assistance is under tab 8. Is the document displayed? Thank you. Witness, have you had the time to look at this document?
I've looked at document KenOTP 00585554, witness exhibit and exhibits produced to the proceedings.
Thank you, witness. Do you recognize this document?
I recognize this document. It's the list witness and exhibit produced at the proceeding, and this was witness number 1 and the exhibits that were produced.
Who prepared this page?
I prepared this page.
For what purposes did you prepare this page?
For record purposes.
Now, when you say this was witness number 1, do you mean Major General Hussein Ali?
Yes, Major General Hussein Ali was witness number 1. That's why his exhibit is number 1A, as I had earlier on explained.
You said that you created it for record purposes. Can you briefly explain what that purpose was?
I created it for record purposes and for ease of reference, so that the exhibits and the witness numbers could flow, and it will be easy for the commissioners and the assisting counsel and the other parties to follow up in a systematic way.
Did you prepare this table before or after General Ali testified before the CPEV?
I can say when he was giving evidence, I was doing notes. So the table was after, but the notes, and I extracted the table from my notes. So I prepared it during and after.
Can we please now turn to the second page in this document, which is ERN number 00058555.
Yes,
Can you see it?
I can see it.
Can you tell the court what this page represents?
This page represents clips on post-election violence. Since since there were CDs, so I just had to prepare a paper representing the exhibits, that there were clips played, the clips on violence from various parts of the country, and I gave it as exhibit number 1A.
Is that correct, that those clips that you are referring to were played?
I'm sorry to interrupt. None of this document appears on our list that was provided at lunchtime, so I assumed it wasn't going to be referred to. but now it is. Can the prosecution please indicate which part of the document at our tab 11, I think it would be, your tab 11, that is 005-8554, is going to be discussed? Because, as I say, we haven't had an indication of that.
If I may respond, when there is no indication of the relevant pages, is because the prosecution intends to tender the document in its entirety.
Well, if that's the case, then I think we should have been informed that that was the position. And I don't know, presumably, I don't know if that applies to any other document. This particular document runs to about 212 pages. So it's going to take, of varied content, and of course, we'll make due comment about that. So, but if the prosecution could let us know what other documents are going to be referred to that are not on the list that we've got. I've only got 3 documents where particular pages have been indicated, and I've got 3 documents that the prosecution are seeking to mark for identification only. So that would leave, I think, about 4 or 5 other documents. I should also say that this document appears and was discussed by Your Honours at paragraph 65 of your decision of last week, and not admitted.
If I may respond, it is precisely for that reason that I'm asking additional questions to the witness to address some of the problematic areas of this document that were identified by the Chamber in their decision. However, in order to address the concern of my learned friend from the other side, I can indicate this document that we are analyzing now, under tab 8, we intend to seek it in its entirety, as I just explained. As per our email before the afternoon session, the second document we intend to show the witness this afternoon with highlighted sections is CAN OTP 0002-0015. The other document for which we provided the relevant sections is 0002-0391. The other document that were communicated to the defense last week, we intend to seek in their entirety.
Can you specify what those are, please?
Certainly. They're all the other documents in the bundle, but starting with CAN OTP 006-1061. Zero 0391. The remaining documents, as indicated in our email, the prosecution will seek to be given MFI codes.
Now, the defense was asking you the objection that began with was that on the page 8554, three documents are indicated. Exhibit 1A, that would be presentation of clips on violence in various parts of the country. And there's Exhibit 1B, which is Police Commissioner's submission, and Exhibit 1C, the report of the police. Where is the report of the police? What page does it appear at?
Yes, Your Honor, that was the third document that I intended to pay, or rather a page that I intended to show to the witness, but the report appears at page 00058567.
All right. We will take these one at a time. I see they all bundled up in the under 8554 under that tab. And you say you seek to remedy some of the difficulties identified by the chamber in the bar table decision. Can we take these one at a time? Exhibit 1B, for example. Let's discuss this with the witness and then we see how we go from there.
Yes, Your Honor. If you allow to continue on the examination, I intended to allow the witness to explain how this document was put together.
Please proceed.
Thank you. Witness, we were discussing the second page of this document, which is 8555, and you said there were clips presented. And my question was, were those clips presented during the testimony of Mr. Ali?
Yes, the clips were presented during the testimony of Mr. Ali.
Can you now please turn?
Sorry to interrupt. It just seems opportunity or convenient to do it as we come to it. We haven't, as far as we know, ever had service of those clips. I don't know if my friend can confirm that's the case or whether it's an oversight on our part. As far as we know, we've not had disclosure of them.
Let's proceed for now and see what counsel seeks to do.
Thank you, Your Honor. Could you please look at the third page in this document, which is 00058556.
Yes, I've looked at 8556. This was by Commissioner Major General Ali, his submissions to the Commission.
Who marked this document at the top of the page?
At the top of the page, it is the assisting counsel who marked it. This document was partially produced in private, and he marked it. The 1B in bold, I'm the one who marked it 1B because he had just marked it as 2B. As you can see, there's a 2B, but I marked it 1B to correct so that it coincides with my list of exhibits. So the 1B is I. The exhibit, it is the assisting counsel.
Thank you, witness. Could we now turn to page 00058567? And this is the section of the report that should remain confidential.
Please proceed with the questions.
Thank you, Your Honor. I'm not sure if you, at this point, can see the document, but it will be displayed in a couple of seconds.
Ms. Sago, I've been wondering, do you need to treat both documents together? That may be the source of your difficulty with the defense counsel. They may be related in terms of the overall source of these documents, but the defense counsel have complained about the length of the documents you intended to use, and that length becomes apparent if you are judging length from the tab 3 that we have here. But then tab 3 seems to have 3 items. If you broke down tab 3 into the separate 3 items, not all the documents are as lengthy as the counsel for the defense might worry about. So that's why I was wondering whether it doesn't serve you better to take this document one at a time, or whether you must treat all of them as one document. It's up to you.
I can provide an explanation as to the reasons why we approach this document as one sole document, and it is because the chamber has, in your decision, has identified certain areas of unclarity. This document was not clear, apparently, to the chamber. The provenance, the authorship, the date, and how this document was put together. And without prejudice to the evidence the witness may provide, the witness is in a position to explain, to address those areas that are unclear to the chamber as to what is this document about and why are we looking at 3 different documents that appear to be separate documents, why are they all together? And the witness may be in a position to provide that clarity to Your Honor's concerns. With respect to the length of the document, I can say that the document had been disclosed in July 2011 to the defense. It's not a new document, has been released recently, has been referred, if I'm not mistaken, in previous documents, in previous submissions of the prosecution. Therefore, the information is not novel. As we will address the document later on, it covers certain topics that have already been addressed in this proceedings.
Please proceed.
Thank you, Your Honor. Witness, we're looking at this page. Is it in front of you? The last 4 digits are 8567.
Yes, it's in front of me.
Can you tell the court what this document is?
This is the Kenya Police report in relation to the December 2007 post-election violence, marked as Exhibit 1C. The markings were done by me.
And when was this document tendered before CPEV?
It was tendered when Major General Ali gave evidence.
Can you please look at the top of the page? On the right-hand side, there are some stamps, and I see at least a 00 in the page that we are looking at. Can you see that?
I can see that. The 00, it's I who crossed. When this document was tendered to the commission, it was not paginated. And we had to reproduce, because it was produced as a single copy. So I had to paginate it. So I'm the one who crossed the 100, but the next page is number 1001. So we have paginated it for continuity and for ease of reference with the commissioners and the assisting counsel. So I paginated the document so that it will have a sequence and clear identification. I paginated it at the commission.
So am I correct in understanding that these 4 items that we have looked at, the first page, the second page, the third page, and the 4th page, the last one that you just commented upon, belong to items that were assembled together by you concerning evidence stemming from General Ali's submission?
Yes, it's true.
With respect to this 4th item, the Kenya Police report, was it introduced during General Ali's testimony? Can you confirm that?
I confirm that.
I have no further questions with respect to this item. Depending on whether the chamber is minded to accept the proposal that the witness is excused, I have no further questions to ask him about the documents we intend to tender today.
All right, so let's deal with this document then. You are seeking to tender, there are really 3 documents, isn't it? You've just dealt with. You seek to tender them onto the record as exhibits, is that it?
Yes, Your Honor.
Now, the first one is merely a label, isn't it? Presentation of clips and violence in various parts of the country, exhibit number 1A. Doesn't say anything else.
The first page, we consider the first page to be 8554, which is really the preface to the collection of further items to follow. We can dispense with the second page, 8555. The prosecution does not intend to rely upon this page or any underlying video material that might be associated with its clips. The third document that the prosecution intends to rely upon starts at page 8556. And the third item, part of this larger document, starts at page 8567.
All right. The first substantive document, as it were, a submission by the Commissioner of Police to the Commission investigating the post-election violence, marked Exhibit 1B, as the witness explained, being the record information from the CPAV. It's a document of 10 pages. Defense counsel,
That is correct.
the prosecution seeks the admission of this onto the record. Any objection, and why?
Yes. Does your Honour wish to receive submissions now? It would seem to be appropriate. They won't be lengthy.
I'm sorry to interrupt you. I would like to make the submissions on the substance and the reasons why we intend to tender this document. It might be more efficient than the submissions that we had before when the defense started with the legal submission.
Sorry, I understood you to say you hadn't wanted to say any further, make any further observations on the document. Sorry.
I said I didn't want to ask more questions to the witness.
All right, that clarifies the matter. My understanding, too, was that you were seeking to introduce the documents then. Yes, please proceed then.
The prosecution intends to tender this document into evidence and rely upon this document, again, for background purposes. The fact that the document was rejected by Your Honours in the bar table motion decision of 10 January should not preclude the prosecution's ability to seek to introduce this document again through a witness when the opportunity is available. In fact, the Chamber already found that this document was prima facie relevant, but lacked certain minimum indicia of reliability. However, the Chamber indicated that the document was not admitted, could not be admitted in this manner, meaning the bar table motion, but we submit that this witness is in a position to establish a connection to the document and provide minimum indicia of reliability that were lacking before when the Chamber examined this document in the context of the bar table motion. The first limb, therefore, for admission, which is the connection to the witness in the prosecution submission, has been satisfied, as the witness has explained the origin of the document and how the document was compiled and put together and for what purposes. The prosecution also submit that the document is prima facie relevant. It has been prepared in the ordinary course of the functions of the police during the post-election violence and the period immediately preceding the violence. In particular, the Kenya Police Report is a compilation of different data that the police collected from the police, the district commissioners in the field, in the different areas affected by the violence. It contains as well contemporaneous instructions or information that the police, based on their own investigations or their own information, distributed to the media to inform the media with accuracy of information about the incidents that were reported. The documents, most of the documents are authored. The police commissioners are identified. There is a date of when the documents were compiled. And moreover, the information is corroborative of other information concerning, again, the violence, the widespread nature of the violence during the post-election violence period, about the tension between the political parties and the media reporting. There is no reference, specific reference in the media reporting to the accused, in particular Mr. Sang. And as far as the documents collected under the Kenya police report do not mention by name the accused. For all these reasons, we believe that the probative value or the relation between this document and the charges has also been established. The prima facie or the indicia of reliability also criteria has been met for this document. And the prejudice to the defense, in light of the fact that the prosecution intends to rely upon this document for background, again, purposes, should be considered in favor of omitting this document. I should indicate as well that not only this chamber, but the trial chamber in Bemba has indicated that investigation reports or reports of an investigative nature can be admitted as long as the prosecution does not intend to rely upon for the substantive charges in the case. And we submit that this document falls within the scope of this general scope of documents that can be admitted and are not prejudicial to the defense. Thank you.
Thank you. Essentially, your submission is that in the bar table decision, the chamber indicated that this document was not signed. It's an unsigned document, amongst other things. And you're saying that the witness has come here and told the court that indeed this is the document that the CPAV had received from the Commissioner of Police.
That is correct, Your Honor.
Mr. Hooper, you are beginning to address the matter?
Yes. Well, our starting point necessarily would be your paragraph 65 of your decision 1353 of the 10th of June, decision on the prosecution's request for admission of documentary evidence, where you've had a view of this document. That was document 24 in the bar table annex. And the chamber considers that the document is prima facie relevant. It reads, however, the chamber notes there are no dates, official seal, titles, or signatures on the first page. It's not clear who generated this page. That first page appears to be essentially unquote, that page seems essentially to be just a record as we've seen. doesn't really take it any further. I've got no further submissions to make on that, other than as a side to request disclosure of the video clips. The second exhibit of the three is observed by the judges as the submission by the police commissioner before the SIPEV. Bears on its first page a seal of the Kenya police and the title indicating the content and a date, but is unsigned. So that's your comment on that. The third document, you observe, quote, in respect to the Kenyan police report, the Chamber notes that apart from the title on the first page, there is no indication of who the author of the report is. There is no seal or official sign, no date of production, no signature, and no formal ending. The report also talks about up to 10 schedules, annexes, whereas the schedule annexed are only 8. Therefore, you conclude, it is not certain, quote, if the complete document with all the annexes is being presented. For these reasons, the Chamber finds that the document lacks the minimum indicia of reliability and therefore cannot be admitted into evidence in this manner. The Chamber does not admit 0058554, which is, of course, the complete document that you have in your bundle. And those concerns are not, in fact, addressed this afternoon any further, as I understand it.
We're now dealing with the second document, the second exhibit, as the material was referred to in the bar table motion. We're not yet dealing with the last document.
That is the various schedules. Very well. I'm sorry, I misled myself in respect to that. Well, let me come then to the submission by the Commissioner of Police. One bears in mind that Mr. Ali, of course, was himself accused and brought to this court. He was one of the accused whose case was not confirmed by the confirmation chamber. But now it's his statement that is being sought to be relied upon by the prosecution. That's a unique situation, perhaps peculiar to Mr. Ali and his statement. One will bear in mind that part of the background that the court has already heard is, of course, the very substantial numbers of civilians who were shot by the police.
What are we to make, Mr. Hooper, of the fact that Mr. Ali was sought to be indicted but the pretrial chamber did not confirm that indictment? Why is that important?
It's an aspect, it's certainly a feature, it's certainly unusual, because we have here effectively a statement by a witness, as far as this bundle is concerned, who was himself charged as an accused by the office of the prosecutor. So there might be an interest straight away of providing perhaps a self-serving statement. And immediately one's therefore in a position to reflect that this particular statement may have less probative value for that reason alone. And perhaps...
Don't you need to address us specifically as to what those self-serving statements might be, as opposed to simply saying, well, the man was once sought by the prosecutor, therefore for the rest of his life he may not be trusted?
Well, not so much that, but perhaps his particular gloss or view in respect of the post-election violence and its causes, which are touched upon in this opening salvo by Mr. Ali in front of SIPEV, who are, of course, investigating the violence of SIPEV, and therefore his role and duty as well, it may be that he had a certain interest. And we see in the very first paragraph that he makes this observation in the second. I'll read the first preamble there. This is on page 8557. This is his opening salvo. Quote, "My lords, for the record, we have already presented to the Commission the official report of the Kenya Police on the post-election violence. The report is comprehensive, factual and detailed. I also wish to emphasize that the Kenya Police is the only, his emphasis, the only, underlined in bold, institution with a factual chronology of all the events relating to the post-election violence. I state this to distinguish the police report from other documents that may be presented to this Commission, which may not be factual and could be coloured by political or tribal bias." So in the very outset, he's saying this is a pure document, no bias attached. Background, 500 Kenyans shot by police in the post-election violence, 50% of the casualties.
We also see here, page 8 of his submissions, page 8, the bottom paragraph, for example, beginning with, "My lords, the contribution of the criminal justice system is to national reconciliation requires that justice constitute the first step towards national healing. No country can forge internal harmony without justice," unquote. Things like that. Do you object to that sort of thing?
No, I'm sure he's going to pepper and salt this particular opening statement appropriately. And at the end, at page 10 of the document itself, that's 8566, I see he says this, "Finally, allow me to emphasize two important points I made earlier. The first is to discount as false and baseless the accusation leveled against the police on the alleged use of excessive force," unquote. So this is General Ali flying the flag of the Kenyan Police Service and doing it quite plainly in our submission. But to admit this statement is to surely breach Rule 68. How does the prosecution really, how can it justify, if it wants to rely on this kind of thing, producing this kind of document and not calling the witness? They want the witness, General Ali, and he's available. They know that. They brought him here. They should call him. So this is backdoor witnessing, clearly testimonial in nature, and for that reason, as indeed you've observed in your decision in respect of other documents, it should not be admitted. Those are my submissions in respect of his statement. As I understand it, we haven't yet addressed the remaining 200 pages of the third document, as it were. So I'll come back to that in due course.
Mr. Kinkatwa?
I'll make the submission. We fully support the arguments just made by the Ruto defense. It's clearly testimonial, so it cannot be admitted in this way. In terms of adding to what my learned colleague said, there's some other paragraphs I would like to refer to that also indicate that he has clearly at heart to exculpate the police force in his statement. And of course, the statement was made to the Commission without being cross-examined. So that's our concern. At page 2, Generali says that I wish to state from the outset that the post-election violence was not a result of any security problem. It was a dispute over the results of the presidential elections and therefore a purely political problem. The violence was neither perpetrated nor directed at the police, but it was rather citizens who, for over 2 months, engaged in violence based on political and tribal differences. This is, first of all, it is a conclusion on the violence and how it occurred, and it does exempt the police. At page 4 as well, at the end of that page, he states, "We find such accusations," and the accusations being of excessive use of force, he finds them to be false, unjustified, and self-serving. And also above this, they say, and I'm not disputing at this stage whether or not he has a point, but the point is that we haven't been able to cross-examine him, and he could be called. He hasn't been. So, and otherwise, I support what has already been stated.
Cross-examine him on what?
Mr. President, we cannot see this statement in isolation. This leads to a whole lot of other documents. And even even if we look at this in isolation, there are hints, as I just read out. He has made some submissions on what the violence is about. We cannot accept them without having seen him and being able to cross-examine him, in particular because he is testifying on behalf of the police. That's what the interview is about. And he's seeking to exempt the police, and he's been a suspect in this case.
I'm just waiting for the transcript to appear. As far as I know, General Ali has not been a suspect in this case, has been a suspect or in a parallel case. If I may just rectify the submission just made by my learned friend on the other side. However, that minor point aside, with respect to another point just raised in terms of cross-examination, I'd like to draw the attention, if I may, to the witness statement at paragraph 32, where the witness explained that witnesses generally, before appearing before CPEB, would be cross-examined by the assisting counsel who was assisting the commission. However, if I may also respond on other matters or points raised by Mr. Hooper. First of all, that the statement was the first, or rather second, or first substantive document in this volume of documents. Major Ali's submission or oral submission before CPEV, that was done in his official capacity of chief of police. He was testifying, presumably based on the report that was prepared by the police, which is the second substantive report attached, and it was delivering a summary of the content of the report generated by the police on the basis of the information received from the field. Secondly, the third substantive report, as the witness has explained, was submitted during General Ali's submission before the commission, and presumably one has to infer that that document was prepared for the purposes of introducing that report before CPEV. Therefore, it was prepared in the course of the preparation for that testimony before the commission. With respect to the different testimonial evidence, our understanding is that testimonial evidence is highly prejudicial to the accused if the testimonial evidence is used to prove the substantive matters at stake in the case. In the specific instance, we intend to rely, again, for background purposes. Therefore, the threshold or the prejudice to the accused in terms of testimonial evidence should be considered in a different manner, as if it were for other purpose, tender for other purposes. Thank you. If
The Chamber will admit this particular document onto the record. The Chamber is mindful of the deficiencies that had been identified in the decision on the bar table motion. In particular, that there was no indication as to who this document came from in terms of signature and the who authored it. The witness on the stand has now given that corrective information. The defense have not argued specifically on how it is that this document might be considered to have a prejudicial effect that is greater or that outweighs the probative value of the background information that is indicated in it. On that basis, the Chamber overrules the objection and admits the document as the next in the prosecution exhibit.
Which pages are that? I take it's just it's General Ali's introductory statement, I take it.
Yes.
Right.
The submission by the Commissioner of Police to the Commission investigating the post-election violence that goes from page 8556 to 8566.
This document will bear the following number: EVD T OTP 00090, and will also be referenced as prosecution exhibit number 90. The document will be registered as confidential.
Thank you. Prosecutor, your next document.
the next document we would like to tender into evidence is 00058567. Up to 8657. The prosecution intends to rely upon this document.
1 second. Did you say up to 8657?
8765.
Take that again, please. Just the range of the document, from what page to what page?
Starting at 0005 8567, ending at 0005 005 8765.
Yes, proceed.
The prosecution intends to rely upon this document, again, for background purposes. The prosecution submits that these specific documents constituted the basis of General Ali's oral submission before the Commission. It is composed of or made of reports that were generated from the different areas affected by the violence, and they were prepared in the ordinary course of the business of the police at the time it was confronted with the violence or confronted with tension prior to the violence. In particular, there were reports that were sent from the field and to the HQ. We can see examples of those reports at page 8591, 8593, 8597, 8605, 8607, 8608, 8610. They were also, it includes also pictures taken contemporaneously to the event or immediately after the event. They identify the location of the places portrayed in the pictures, the period and the time in which the pictures referred to or were taken, and they portray and represent information that is corroborative in nature, that has already been presented, including by witness, before this chamber, or included in other documents admitted by the chamber in the bar table motion. As indicated previously, this chamber, but also other chambers, in particular the trial chamber in Bemba, have admitted documents generated for investigation purposes. In particular, they refer to NGOs, but other investigative reports as well. Can be admitted because the chamber will conduct its own fact-finding mission of establishing the truth and distilling the relevant evidence in the documents that is not prejudicial to the accused. The prosecution again reiterates that this document is to be relied only for background purposes, and there is no, or I should say minimal, reference to the accused in this case. And even if there were, the prosecution does not intend to rely on those portions. However, for completeness for completeness purposes and to allow the chamber to appreciate in its totality the nature and relevance of this document, the prosecution is tendering this document in its entirety, because the Chamber may appreciate better in light of all the information collected by the police and assembled for the purpose of General Ali's presentation before CPEV with respect to the post-election violence and the response by the police to that emergency. For all those reasons, the prosecution submits that this document meets the minimum criteria for admissibility. A link with this witness has been established. The information contained therein is relevant to matters and issues before this chamber. The document also has or bears indicia of reliability, such as dates, signatures. The witness has clarified that this document was tendered through the police commissioner, arguably in a position to represent the police before a formal commission of inquiry. And finally, the prejudice to the defense is minimal. This concludes our submissions. Thank you, Your Honor.
The defense will be pointing out, I presume, that we still don't have two schedules for annexes, 9 and 10.
That is,
What is your explanation about a missing annexes?
the explanation is, and I apologize not to have mentioned it before, I should have, is that the document was transferred to the office of the prosecutor in this status, and the prosecution has not been able to obtain the missing schedules or annexes as they are referred in the document. Therefore, it's entire in the sense that it is complete to the extent that the prosecution has received this document in this condition.
And the missing schedules, they relate to details of loss of property, as in for Schedule 9 and 10 is about official details on the number of internally displaced persons. Is that the case?
We haven't seen the two missing schedules ourselves. We go by the description contained in the report itself at page 8578, which describes the annexes. However, the prosecution submits that the missing information in this report shouldn't detract from the validity of the rest of that report because they can be analyzed separately. They deal with different topics and they are not necessarily intertwined. Therefore, the document, even if in its partial form, is representative of what it portrays to represent.
All right. Mr. Hooper or Mr. Nkatwa?
Well, there is the concern that was raised in your previous observations in relation to the missing two schedules. There are parts of these documents that the Chamber may find relevant, certainly as far as background is concerned. But pitching in 200 pages of material like this is not particularly helpful, particularly when the prosecution has had, what, a month to prepare, really, for addressing this kind of situation. And if we go through from page 8568, that is the effective commencement of the executive summary. First of all, we don't in fact know who compiled the report. That's never been provided, or the methodology, or those other elements. We don't know. This first part, the introduction, gives a history of the Kenyan police, guidelines on the use of firearms, and so on, which the court may find, I don't know, of some, albeit minimal, interest. Then we get to page 8576. Interestingly, there we have the same three criminal gangs mentioned, Mungiki, Taliban, and the Chinkororo. We don't know who they are. But we're there dealing a little more with the substance of the court's function as fact finders. And it's when it comes to these elements that the defence raises concerns, because at this stage, we don't know what's going to appear in a half-time submission by the prosecution or a closing brief by the prosecution. And it becomes lost to sight when you have 200 pages or so. So the defence are naturally cautious and concerned that there may be something lurking in the woodwork here that will come out to haunt us later.
But isn't it something we will need to deal with when the time comes?
Well,
the prosecution has said that they do not intend to use any element of this document that may have made any allegation against your client. That's not why they are seeking to introduce it. For your own purposes also, look at the gangs you mentioned. Those are three gangs. Mungiki, Taliban, Chinkororo. There was a witness we had who came, an expert witness, gave testimony about Mungiki, for instance, that seemed to be of interest to you. So, why is this something prejudicial to you?
Who's to supply this information? You might look at that and might think that they're some Rift Valley gang. They're not a Rift Valley gang, not the three of them. So it's the ability to deal with matters like that. And that page. Then you move on, and we have analysis of police action. And that's fairly self-serving in the sense that it exonerates the police of any wrongdoing. And then at 8581, we have conclusions. And we'd submit that those conclusions shouldn't form any part of the admitted material, because to do so subverts or may subvert your judicial function in terms of finding of fact. Because if we look at paragraph 20, the police are saying, of course, here, all indications are that the violence was premeditated and meticulously planned to serve political expediency. And that is not a matter that should come lurking on the bottom of a page in the middle of such a disparate selection of material, when it's, of course, core to the case. So objected 20 to paragraph 24, objecting to the conclusions there. And then we come on to selected pre-election mood press reports. Now, we don't know who's done this selection. We've not seen the original reports, but this is at page 8584 and its following page. Very short items. a matter of principle that we say matters shouldn't be admitted in such a casual way as the prosecution are suggesting these may be. And there's a similar document a bit further on. And then we move on to 8586, Police Commissioner statements. And how these are meant to help the court, I'm not entirely clear. First page, a speech by the Commissioner of Police to media executives. Well, I don't know if that speech was ever made, in fact. We've had no other evidence of such a speech being made. And we're not clear who the Commissioner is, who's being spoken about there. Is it meant to be Mr. Ali? We don't know. At 8591, there's what appears to be a letter, but to whom? It's not marked. The addressee is omitted. And it's difficult to see quite how that assists, or the prosecution would think it would assist. Over the page at 8593, a summary of reported cases of electoral violence. Again, if we look at that, I don't see anything on the Rift Valley there. And indeed, there's a sequence of such summaries, nothing to do with the Rift Valley. And then we come to page 8600. I'm handicapped because I don't speak or read Swahili, which is the language I assume we find on that and subsequent pages. So there's a chunk of this which is even in a language which is untranslated. And that concludes at 8604. And apparently it's something that Major Ali said, but what he says, I'm afraid I have no idea. And then there's another letter.
Is that the case that your clients will complain about the use of Swahili, or that there is no member of your team?
Well, I do.
Oh, one second, I haven't finished. That your team are not in a position to understand Kiswahili? The fact that you don't.
We've no Swahili speakers on this team gathered here today. There is some, I think, rulings of the court, and certainly other courts, that if there is a document in a foreign language which is sought to be relied on, it should and is translated into one of the languages of the court. And that's a precondition of the service of any document. And because we're dealing with matters like this in this way, doesn't mean that we should abandon what are rules which are introduced, of course, for essential fairness. I take your honour's point. Of course, there are those in this courtroom who can speak Swahili. I could go to my friend Mr. Catwell and he could read it to me. But why should we have to be dealing with matters like this? If it's significant enough for the prosecution to want to introduce it, they should provide a transcription for us.
Yes, Mr. Hooper, if
Well,
we can make it quick so we can...
Is on next page 8607, another letter. Over the page to 8608, again, a letter to a news editor from the commissioner. Again, I don't know whether these letters were contemporaneous with the date they have on them. I don't know to what extent these are all self-serving documents to get the Commissioner, Mr. Ali, off the hook. I don't know. But we do know that, for example, on that page, 8608, We've got yesterday, the 2nd of January, violence in a church at KenyaMOJA, described as an act of genocide. And we'd ask certainly that that page 8608 is withdrawn. In fact, those letters seem to perform no useful function in the case. And at 8612, we come again to selected press reports, rather more extensive, half a dozen pages. Again, we don't have access to the reports themselves. We don't know who summarized these. We don't know if it's an accurate summary. We don't know what else was omitted from the relevant papers. And we've got no one to question because we don't know even who composed that. 8618, we have a list of 15, I think it is, gangs. We don't know anything about them. None of them, as far as we know, are Kalenjin groupings. And then Schedule 5 is photographic images of violence. There's only, I think, 3 of these that relate to Eldoret. Some, for example, at 8623 relate to KenyaMOJA. At least one's defined there as relating to KenyaMOJA Church. The others are not. That's essentially the Eldoret content. There's another Eldoret-related photograph at 8633, 2 photographs, one of families forced out of their homes and displaced persons. But again, one would have thought that there was a more appropriate portal or witness to produce photographs specific to Eldoret. As far as I know, those are the only 4 or 6 photographs relating to this case, and the others are all of elsewhere. Schedule 6, major incidents reported. Again, we don't know anything about how this report of major incidents was composed. At 8651, we have the Rift Valley, and we have various matters there that do touch upon, of course, issues directly related to the factual findings that this court's going to have to make on evidence of witnesses that it's heard. But these are, as it were, being sought to be admitted without the capacity really to examine their source at all, and of course relate to anonymous witnesses, which the court has been quite clearly concerned about as weakening a right of admission throughout the decision of the 10th of June. Then we come to details of cases before court. And that really concerns that Schedule 7A at 8662. I don't comment on that. We have a further schedule relating to cases pending in Rift Valley at 8678. We don't object to that particular document. And I say that without, I hope, tying us down too much to any particular detail that may run through it. There's about 2,000 pending cases, it would appear from that document, which more or less takes us to the end. And Schedule 8, which is deaths under investigation in Rift Valley, which contains the names of 121, but is only page 3 of 18 pages. If we look at the last page, that's 8765, it's again an incomplete document. So on that review, Your Honour, I did it in that way. There's background material there that you, the judges, may find of interest. There's a lot of material which seems utterly irrelevant. There's a lot of material which is unspecific. There's a lot of, in terms of incidents, anonymous sources which should not be relied upon, and those pages should not be relied upon. As proof of the contents of fact. So it's a bit of a mixed bag, we'd say, this particular third document or second document that the prosecution want to have exhibited. And I hope to a great extent I've highlighted those matters that the defence are concerned about and the reasons why that is so. And we're very mindful, of course, because of your decision, the approach that you, the judges, have already taken in respect of material, and where, if I can put it like this, your attitude to the document and ours concurs to the extent that weight is not placed on obvious prejudicial matters, anonymized matters, anonymous matters, and other irrelevancies.
Ms. Bausman.
Thank you, Mr. President. I will not repeat all that my learned colleague has said. We, again, fully support these submissions. We wish to point out that there is a regulation, that is Regulation 39.1 of the Court, and this specifically states that all documents and materials filed with the registry shall be in English or French unless otherwise provided in the statute, rules, these regulations are authorized by the Chamber or the Presidency. And if the original document is not in one of these languages, a participant shall attach a translation thereof. On this basis, the single judge has excluded documents in our case that we sought to tender during the confirmation hearing. And I give you the number, it's decision number 300, where they rely on this regulation to exclude evidence on that basis.
On what basis?
On the basis that it wasn't translated into English or French.
But there must be some common sense to it. And one can understand where the documents that no one in your team can understand, including your client, has been introduced. But there are lawyers in your team that understand Kiswahili, and so does your client. Are you telling us that we should exclude the document simply because it's in Kiswahili?
Indeed, Mr. President, it's not just about us, it's about you, the judges, as well. None of you speak Kiswahili. You have to assess this evidence, and it has to be in one of the languages of the court. And when we try to introduce evidence that wasn't translated into English or French, we also had our own speakers on our side, and yet they excluded it on that basis. In particular for us, there is a concern because there is a direct reference in the untranslated Swahili parts of the report at page 8603. This particular reference is to CAS FM. And well, I cannot translate it for you, but obviously if there's some specific indication like that, it should at least be in English so that the judges can understand what it says.
But that is something that can easily be dealt with, isn't it? Prosecution will undertake to translate those documents if we do admit the material.
Of course, certainly. Certainly, Your Honor.
That would certainly be a condition that we would seek. But even if it was translated, it is a reference, direct reference to CAS FM, which is again something that directly involves our client and which is incriminatory. There's other references, but Mr. Ruto already referred to them, certain conclusions. There are, in fact, in disputes at page 8576. We've brought evidence to your attention that directly denies the second point about the allegations of rigging, at least on the radio. So these are references that are incriminatory, which are very prejudicial to us, and the report is incomplete, and with all the deficits that you have already indicated in your decision. And just one more point. Nothing has changed since the decision was issued and since today. This witness doesn't help rectify all these deficits because he wasn't someone who was part of compiling this particular report. So all the complaints we had before that you've recognized as valid, they still stand, Mr. President. There's one more reference that we are concerned with, which is more of a general nature, but it does refer to hate speech. And since we're not sure how this document is going to be used as background evidence, that is also of concern, and it starts at page 8587. So these are our concerns. And of course, one last point. If your honors decide that it can be translated, then we think it's only fair that we discuss admissibility at that stage. Because at this moment, there's all this Swahili that maybe some of us, but not all of us, can give you very good observations on. So in that situation, we should defer to a later stage.
The Chamber's ruling is this. The prosecution has said that the purpose in admitting this document or seeking to admit it is purely for background information, and such background information would include what the police said they were doing and what they said they had observed. We are alive, of course, to the difficulty with incriminating material being dredged in through this document, and that will not be the case because the prosecution has indicated that that is not what they intend to do with it. So we will admit the document, and the defense will make submissions at the end of the day, if the prosecution does try to exceed the purpose for which they said they had sought to tender the document, we will leave it at that and move on. And the prosecution will, of course, supply the interpretation of the parts of the document that are in Kiswahili.
This document will bear the following number: EVD T OTP 00091, and will be also referenced as prosecution exhibit number 91. Thank you, Mr. President.
Thank you very much. Ms. Ego?
Very quickly, I understand we're running out of time. I was wondering whether, with respect to the previous document that was not omitted, whether the prosecution could seek an MFI number.
The document will be marked MFI.
Thank you, Your Honor.
Can you give us the reference number again for that document?
The ERN number is KenOTP 00011288. Thank you.
This document will bear the following number: MFI T OTP 00092.
So the understanding now is that for the rest of the testimonies that would ordinarily pertain to this witness, we will be essentially debating admissibility of the documents. Is that it?
Yes, Your Honor, that is correct.
And the defense have offered that they do not contest this witness's general indication that those documents come from CPAV, to the best of his, that he's able to tell us that. Is that the position?
Yes, on our part, yes.
Yes.
We will then be discharging the witness, and there's no need to detain him, or do we see any need? Wasn't
I
that,
understand
was
there may
that
be
your...
some questions from the defence on general matters, not on the documents. So we will need him tomorrow.
You need him tomorrow?
I believe so, yes.
Well, I thought you offered that the witness could be discharged.
Yes, well, we'd suggested that we did our cross first and then return to the documents. But if we've done the documents, or we're doing the documents and then the cross, then...
I
that's
see.
the
So
way.
you still need the witness for
Yeah.
cross-examination. Witness, I thought I was going to cut your stay with us short, but it seems that that's not going to happen. So we will require you to return again tomorrow at 9:30.
Yes, Your Honor.
We will adjourn the proceedings for the day and then resume again tomorrow at 9:30.
All rise. We will wait.